Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer. Now, I have a great topic for you. Today is who gets to stay and who gets to go when you're applying for permanent residence. When I say who gets to stay or go, I mean who gets to stay in the United States to apply for permanent residence, and then who must go to complete their process, who must leave the country, go to the embassy, and complete their permanent residence process there. Thanks so much for the love. I appreciate it. Now, let me remind you that I'm also here to answer your questions. So you can put your questions in the comments and I will answer those questions as they come in. But I got this question today and I got the question. It was asking, how does a son or daughter who is over 21 qualify to apply for adjustment of status? Adjustment of status is the process of applying while you are staying in the United States. The great benefits of adjustment of status is that once you're here and you qualify for adjustment of status, you can then apply for a work permit and you can apply to get a travel document while you wait for your process to be completed. Now, the tricky part here is that not everyone who qualifies to apply for permanent residence is going to qualify for this process called adjustment of status. And that's what I want to talk to you about today so that you don't make a mistake of applying for something that's going to get you into complicate your process. Now, in the case where you are here, you qualify through a family member or an employer, it's at that point that you can apply. So who qualifies? So in regards to family, it's going to be anyone who is here. Your priority date is now current. That means that you are, for example, the National Visa Center is ready to get started on your process because you now have an immigrant visa number available to you. And also, if you have an approved I-130 and you're in status, meaning if you may be here on a visitor's visa, you may be here on another type of employment-based visa, you may be here on a student visa. If that's the case, you could possibly apply for adjustment of status. And that means to stay in the United States and apply for permanent residence. Now, when you are applying, if you are not within this category, the next thing is, are you out of status? If you're out of status, then there still is a possibility for you to be able to adjust status if you fall within a specific criteria. So the first is, are you the immediate relative of a U.S. citizen? What I mean by that, this is not every relative of a U.S. citizen. This is, are you the spouse of a U.S. citizen? Are you the parent of a U.S. citizen who's 21 and up? Are you the son or daughter of a U.S. citizen who is under 21 and unmarried? If you fall within this category and you came in with a visa, so you ended up overstaying, then in a case like that, you could qualify to adjust status to get permanent residence while you wait in the U.S. Now, if you're not the immediate relative of a U.S. citizen, the next question is, do you fall within any of these other criteria? Have you been mistreated by your U.S. citizen or legal permanent resident, spouse, parent, or citizen's son or daughter who's 21 and up? That could qualify you for VAWA. And in the case of VAWA, even if you came into the country without permission, you may qualify for this if you have been mistreated. The next is, did you receive a T visa as a victim of trafficking? Did you receive the U visa as a victim of a crime? If so, then you could qualify for adjustment of status after 3 years of having that status, the T status or the U status. So this, when it comes on to employment, now with employment, you have to fall within the legal status. You have to have legal status, or if you have fallen out of status, then you must be able to have a qualifying relative to apply for a special type of waiver. But guess what? The waiver still wouldn't qualify you to adjust status here. So when it comes on to employment based, you must maintain your legal status here. So in a nutshell, those are the individuals who may qualify for adjustment of status. That's where it's very important to schedule a personal consultation to determine whether you could fall within this category. Now, what if you don't fall into a category where you can stay and apply for your residence here and you're already here? What do you do now? Now, the other is if you are still in compliance with your immigrant status, for example, you have your visa, then you could just go back and go through the consular processing. If you're already here, though, you're stuck here. You may be stuck here, you can't leave, because if you leave, you are going to face a bar. What do you do in this case? Now, in a case like that, if you don't qualify for any of the different groups, that you don't fall within the different groups that I previously described, then you may have to apply for a waiver. Now, the waiver is a special waiver, and you will still need to show that you qualify for this waiver to get forgiveness for your overstay. It doesn't allow you to stay in the US for the entire process, green card process, but it allows you to stay in the US for most of your green card process, and then it allows you to finish your process when you are at the end, when you're attending your interview. So how does this work exactly? And this is what through the I-601A waiver, if you're already here. If you have a US citizen or legal permanent resident spouse or parent who will experience extreme hardship, then you may qualify for this. So let me go ahead and take pause to answer some questions here. Now, keep in mind, put those questions in the comments so that I may answer. So the EAD clock, now with the EAD clock, I think you're referring to the asylum, if you're applying for asylum. Now, after a certain amount of time, if your has passed of the application, so once your application has been filed and it's been pending for a certain amount of time, then you can get a work permit. And so the clock runs, but if, for example, you are the reason that your processing was delayed, that could cause a problem with you getting permanent residence. Getting the work permit based on the asylum. So the clock is a way that they track how long your application has been pending to determine whether you can get the work permit. All right, so please, what happens if your spouse refuses to go with you to the green card interview? So Evet Sela, this may qualify you for VAWA. I would have to determine exactly what's going on within your marriage that is causing your spouse to refuse to go to the interview with you. But in some cases where I see this happening, it is because there's a bigger problem than just refusing to go with you. They may be trying to intentionally sabotage your process. They may have mistreated you all this time. They may be jealous and they don't want to see you moving forward in your process. If this is a situation you're in, you may qualify for VAWA. Now, VAWA allows you to move away from your spouse process to do a self-petition process based on the mistreatment that your spouse may be subjecting you to. And mistreatment means verbal, emotional. It may also mean that you will face extreme cruelty from your spouse. If they're being vindictive, they're trying to stop you from getting your status. That could amount to extreme cruelty. So in this case, you definitely need to schedule a consultation and let's talk about your situation to see if there could be a resolution here for you. But this now with VAWA, what would happen is you would move over to the VAWA process. If you are timely and they don't deny your adjustment of status, you could also keep your adjustment of status application open while you are applying for the VAWA. So that means that it also keeps your work permit going and your travel document going. You can go ahead, give us a call. The number is 561-405-4889. Call us, let's talk about your situation, and I can confirm whether this could be for you. I'm living in Guyana and I had to apply once in 2015 and was turned down and never applied again. So, Alitain, we don't just fill out, so we don't do the visitor's visa applications just because those are not necessarily complex issues, but it depends. So with the visa, if where we fill it out is if you have been previously denied for something, your case is more complex, and we're assisting you through the complexity of the situation, then that's where we can assist. So what you can do is if you have an issue why you never reapplied or you want to figure out whether you can apply, give us a call, then we can evaluate your case and see if it's a case that we can take. Thanks for the gifts. I appreciate it. Now, let me remind you that I'm also on YouTube. So go ahead and put your questions in the comments so that I may answer the question. How long does it take the NVC to schedule an interview in Kingston, Jamaica? So it is taking a bit. I'm seeing anywhere from 3 months to a year, even over a year to get interviews, just because COVID has made things a lot worse. So check on your case, make sure everything is straight on your side, and then it's a waiting game from there. Unless, of course, you're facing an urgent situation, there are ways to request from the embassy that they expedite your case, but it's going to depend on what your circumstances are. Asking for an expedite isn't going to be granted to you just by virtue of asking. You must prove that you have a good reason, and it's really on a case-by-case basis that the embassy usually decides whether they're going to speed up your case. All right, keep putting those questions in the comments. Thank you for the love. I appreciate it. So I came and I talked about applying for who gets to stay, who has to go when you're applying for permanent residence, because not everyone who qualifies for permanent residence who is here in the US will get to stay to finish out their process here. And so I listed out some categories just in summary. The people who may be able to stay here to apply for adjustment of status will be immediate relatives of US citizens. This is going to be the spouse, the parent of an adult citizen, or the son or daughter of a US citizen who is under 21 and unmarried. It's also going to be VAWA applicants. So I just mentioned this previously when I was talking about VAWA. That's if you're being mistreated by a spouse, a parent if you're under 21, under 25 in some cases, or by a US citizen, son or daughter who's 21 and up. If you have the T visa or the U visa. Also, if you do qualify for permanent residence through an employer or any family member, and you are currently maintaining your legal status, you have a current priority date, then at that point, you would be able to adjust status as well, meaning to apply for permanent residence while staying in the United States. At the time that you're applying for adjustment of status, that's when you have to make sure that you can prove your legal status. So that's in summary, those are the people who may be able to stay. Now, who must go? It's going to be anybody who does not fall within this category. So it's going to be individuals who are 21 and over, sons or daughters of US citizens, immediate relatives of US citizens who cross the border without permission. Now, the immediate relatives of US citizens who overstayed their visa or came into the country with permission, they get to stay. But if you cross the border without permission or without inspection, it's going to mean that you're not going to qualify for adjustment of status unless you qualify for VAWA. So as you can see, it is complex. I'm trying to break it down as simply as I can. But in summary, those are the individuals that you have to leave, and you'd have to, there is a relief. Now, if you want to finish your green card process, you would have to leave, but you must make sure that you apply for a waiver first. Usually to apply for this waiver, you need to have a U.S. citizen or legal permanent resident, spouse or parent in order to qualify for this waiver. You should not be leaving the country without first getting legal advice. Remember that I'm giving you very general information, and whether you qualify for any of these benefits is really going to come down to your circumstances. One single fact that's different from anything that I said here could change everything for you. So always schedule a legal consultation to evaluate your options before taking any actions, especially before coming to the US or before leaving the United States. Let me see if we have any more questions. You're welcome, Jaheem. So good day. So if I can't afford a lawyer and choose to file my papers, would the process be longer? So Kalishay, not necessarily, but hiring an attorney is not required. It is definitely something that you should seriously see as an investment, though. The reason being, and if this is your future in the United States, you don't want to mess it up. So, like anything that's valuable to you, you should be making an investment. And here's where I see it could make your process longer. When individuals come to me, they've already filed their application without an attorney. They make mistakes, and they may not be aware of certain laws or regulations or policies. They may not be aware of the best practices to submit the application. And when they submit the application, it may be sloppy. It may not have all the evidence. And because of that, when it goes to the USCIS, they already red flag it. They already put it aside to be scrutinized even more because it may be missing things, or they have to issue a request for evidence. And request for evidence could be a 3-month delay or more. And so where I find that people without attorneys or a good immigration attorney really get into trouble is where they make these kinds of mistakes, and then the USCIS or the National Visa Center takes even longer to process the case. So I would say here, while attorneys are not required, you should really consider investing in one to make sure that you don't compromise your future in the United States. Also, word of caution, don't use those notarios, immigration consultants. They are not going to do you very well either. I mean, if you come out unscathed, you're lucky, but with them, they're not trained attorneys too. And so when they send the application in, there may be things that they're missing, and they would not be able to help you when you do get into trouble. So very important that you consider getting an immigration attorney. And that's why I do this every day. I come on here to bring awareness, to give you the knowledge you need to empower yourself to make informed decisions. And so based on what I've told you, you can make an informed decision about what is right for you. Just move forward with caution. Hi there. So you filed for VAWA last year, but my husband is willing to help me. Should I drop my VAWA and let my husband file for me? Wow, Shauna, that is a heavy question. And the whole reason, I don't know what your situation is. I don't know, I'm not your attorney, so I wouldn't be able to tell you exactly what to decide. But what I can say here is there is a pattern when it comes on to abusive relationships like this. Usually my clients turn to VAWA because they really cannot depend on the abusive spouse to go through the entire process with them. And so VAWA gives them the option it gives them self-determination. They don't have to depend on the spouse. They don't have to worry about the spouse sabotaging their immigration process. They don't have to worry about the spouse abandoning them. They don't have to worry about the spouse walking out on them. They don't have to worry about the spouse writing a letter to immigration saying that it was fraud, because you do have spouses that do exactly that. They write to the immigration service, say they're withdrawing their petition and that you were only in it for the green card. So what I would say here is that it is up to you. And if you really want to sit down and make a decision like that, you should definitely schedule a consultation if you don't already have an attorney. If you have an attorney, consult your attorney. But this is a big decision, because if you drop your VAWA case, it means that you are at the mercy of that husband. And if that husband decides to get up and take out, subject you to the extreme cruelty or abuse, then that is going to put you at a disadvantage, especially when you have to run back and file for another VAWA and start from scratch. Hi, I just got a mail saying all documents I submitted to the NVC are qualified. When do I get an interview? So Commie Scamp, unfortunately, the interview may not be right away. It depends on the embassy, depends on how backed up they are, but I'm seeing anywhere from 3 months to a year to get interviews. And now it's even going over a year for some people. All right, so thank you for your questions. These were all great questions. I'm not finished though yet. I'm heading on over to Instagram, so you can hop on over there to continue to ask your questions. Shauna Bless, I'm glad that you've taken what I've said into consideration, and good luck with everything. And also remember, I'm here to help. So if you have any questions, you can always schedule a consultation to evaluate your options. If someone goes to the US with a visitor's visa and get married to someone with a green card or citizenship, so John, that is going to depend. So if you marry someone who is a permanent resident, you have to be very careful, because you have to then have a current priority date, and you have to make sure that you are qualified in every way for adjustment of status. If you marry a US citizen, even if you fall out of status, there may be the possibility to apply. So whether that's going to work is going to depend on who you married, what their current status is, and what's your situation in regards to your visitor's visa. All right, thanks everyone for your questions. I'm going to head over to Instagram. Instagram is The Immigration Attorney. I'm also going on to Facebook. It's the name of the law firm, ST Law Office. So you can find me on any one of those. If you want to continue asking your questions or you want to continue this conversation, I will be over there in a quick minute. Thanks again for joining me. John 1000, you're welcome. Now I am here every day, Monday to Friday, for around 4 p.m. Eastern time to take your questions and also to bring a topic. So go ahead, plan out your day, and hopefully you can fit me in to get some information and also to ask your questions in the comments. Thanks everyone, have a good one. And also remember, if I don't see you in a minute, I'm hoping to also speak with you in a consultation, because the information I gave you is not personal legal advice. It's general information. And so you want to make sure that you get the personalized legal advice that you deserve to plan out your future in the United States. Have a good one. Have a good one on YouTube as well. Bye-bye.